Good morning, everyone, and once again, it's a real pleasure for me to be here and see so many happy faces in my first physical environment for more than 13 months. It's quite spectacular. So, I come from SAP. We're in the business of providing enterprise business software globally to 425,000 customers in 180 countries, 25 industries. And I was asked to come and speak to you about the subject of risk, security, and compliance. And these three terms, I think, are very broad-ranging, and they mean a lot of different things for each and every one of us, because we have different perspectives on these three terms, in terms of what is risk, what do we mean by security, and what do we mean by compliance. So today, we're very pleased to have with us these experts on my left who will give their insights from their perspective as to what is meant by these terms and how that affects their perspective on this subject. So we're going to get that as well. So from my side, as you all know, the pandemic has had devastating effects on the world economy, and it has really shown how vulnerable companies and government organisations really are in the face of all of the travel restrictions. We have seen the devastating effects on our families that I'm sure you all can relate to, as well as the impact on the supply chains, logistics, employment, revenue for companies, etc. It has had tremendous negative consequences for many of us. On the flip side of the coin, these challenges, combined with the geopolitical events we've seen globally in the last few years, has also created a lot of opportunities for us. So, from a positive perspective, many companies and organisations have taken advantage of that. So from my perspective, I come from IT, and what I can say is the IT sector sees these challenges from a positive angle. They see an opportunity to help organisations run better and to improve people's lives by offering their technologies to streamline procurement processes, to build interconnected supply chains, which are also environmentally sustainable, and allow companies to be profitable and sustainable in the long term, and serve their customers and ecosystem to make everyone more successful. So what can we do as lawyers? I think when we look at the legal function, especially in this climate, there's a lot we can do. And when we talk about risks, I think we need to take a very holistic view of what we mean by risk. Now, there are many ways of looking at it, but I think you can first of all look at the aptitude for risk. So some companies have a very narrow or conservative view about what risks they will accept in their work. And I take that as an example is a publicly listed company like SAP. For example, we have global processes and procedures, and for that reason we are somewhat constrained in what risks we can take from an operational perspective, as we have global policies and procedures to adhere to. And we also, by virtue of the publicly listed element, we have certain things we would not accept in the form of indemnities, which may represent unlimited liabilities, for for SAP. We also have matters pertaining to the governing law, liquidated damages, and fixed deadlines can also be difficult for us to accept, because not only do we have risks if we can't control the deployment of our solutions, but we also have potentially third parties who are providing products and services underneath our control, and we don't want to be on the hook for third parties who may not meet their contractual obligations towards us. So that's some of the, I guess, the aptitude for risks. And what I see when I negotiate with many of our customers across the industry chain, from airlines to banking to telecoms to oil and gas and many other industries, is that there is a wide divergence in what lawyers and their companies will accept in terms of risk. And therefore, when I meet with the other lawyers, I find we need to see common ground and then determine what is their aptitude for risk and what is my aptitude for risk, and then we try and see where we can make headway to achieve an acceptable mutually commercial agreement. So this is one way that I look at risks. And when we look at compliance, we have a lot of regulatory controls now which are affecting the telecom, the IT sector, and many other industries where we operate. So it's important to keep ahead of the regulatory aspects because we have data residency controls which restrict information which is deemed to be personal, health data, or even government security data from leaving the country. And that creates a lot of risks for large service providers and cloud services providers. And therefore, we need to manage those risks by understanding what we can and cannot do, and also being transparent to our customers to give them an understanding of how our solution works, where their data is being stored and processed, so that if necessary, they can obtain necessary approvals from the regulator. And I do say that because there are really heavy penalties for companies who don't respect the data residency laws, especially in these times where healthcare is so important, and there are specific healthcare laws in many countries where we operate, across Africa, Kenya, South Africa, UAE, Saudi Arabia, Russia, even China. We've got all of these laws that we have to observe. And a lawyer, I think, takes a very holistic view of all these risks, because we also need export control laws and sanctions which may affect our customers. We might need to get ITAR approval, International Traffic in Arms Regulations approval, if there are military elements to our solution, if we're supplying a solution to defence, for example. We have our anti-corruption laws, the FCPA, and local laws, which apply specifically to government sector and also private sector. So that's something to keep aware of. Plus you've got various other regulatory laws and restrictions which affect us, and we need to just make sure we're aware of that, and we proactively communicate that to our business, so that when we submit proposals to customers, we make sure, as far as possible, that we are compliant with the laws and also our own internal processes. We should have robust delegations of authority which can help us manage the many risks out there for our business and also for the wider ambient community. One of the things I notice is that many salespeople, even those ones, the seasoned executives who have a lot of product knowledge and experience and many years under their belt, they still are unable to express themselves clearly. And this is a major issue when they are negotiating with many of our customers, because that leads to misunderstanding. And misunderstanding can lead to unrealistic expectations, even side commitments, which can be a compliance issue for us internally and also lead to financial or legal action with the customers if they think we've misrepresented or we have, recommended something, and even if it's outside our control, we can be held to account for that. So it's important that lawyers are involved early on and we manage these risks proactively in the business before they really become a problem. So without further ado, I now turn to my next guest on the left.
Thank you. Good morning, all of you. Now, we are discussing a topic which is essentially in the realm of dealing with contractual matters in transactional law between corporate entities and other bodies across jurisdictions. Now, in these scenarios, essentially risk is a part of all business. So mitigation of risk is central to all contractual arrangements or business. Now, so far as mitigation of risk is, there are various kinds of risks. There are financial risks, legal risks, risk dealing with security, which I will explain, your brand risks, the company which is doing it because of their, the activity that they choose to, which may affect their brand as such, if they fail to comply with the commitments that they've. That's where the lawyer's role, my experience, where I've dealt with contractual matters across jurisdictions, is very, very crucial. A lawyer must discuss with his client the kind of perceived risks, part of which is to be his own experience. Obviously, a reasonably well-established corporation would go to a reasonably well-established lawyer who will have experience in this matter. And we must rely on that experience to ensure the contract is drafted and spelt in a manner in which that mitigation of that risk, perceived risk, will take place. So when financial risks are concerned, let me give you examples on each one of these. If you were to make part payment or whole of the payment, now wonderful mechanism has evolved over the years, that is letter of credit. Letter of credit, as some of you must know how it works. So an LC is a very good instrument. They have become sophisticated, etc. So therefore, you will have to mitigate the risks by using such methodology and mechanisms by which you can ensure that any financial exposure that is made is sufficiently protected. Now, financial risks are also backed up by insurance companies, where insurance companies will insure your financial exposure. So there is an important aspect of the insurance, agreements to be negotiated for the kind of financial risk that you're taking. So some of that is very important. You can always negotiate with that. Now, legal risks are very important, that you fail to mention something in any one of those contracts as a clause. And that's where it's very serious. It would result in loss to your client because you have failed to perceive the particular language of the clause, the particular the manner in which it is suggested. So it should not convey different. A use of a full stop or a comma or a small word has resulted in confusion. So it's very important that you make sure as lawyers that the meaning is conveyed very clearly, crisply, and that's where your skill would come. So therefore, and it has to be something that you have spent time over, which you've looked at in drafting those clauses or making them sound or convey the meaning that you're suggesting. And then there are issues with respect to security risk, which is you secure your goods and products during the transit, during when they are being shifted from one place to the other. Physical security of aspects of the product is a security risk in terms of, it could also mean your data, that your non-disclosure clauses are very important in businesses. And you must ensure that non-disclosure clauses are very clear in their meaning of what they're conveying when you are going to a business. Also, data that is, the IPR lawyers would tell you that if you shared your project, your client's project with a prospective customer, and if you shared everything, and that man without a non-disclosure clause and securing that, he may your client may face an intellectual property risk where he will utilize the proprietary information that goes to that is shared with a prospective business partner who may not continue to do business but has taken away your proprietary information. One of the biggest intellectual property cases I did in India was a satellite telecommunication project which was shared with a prospective partner. The prospective partner did not sign up and use that entire satellite telecommunication project to his advantage without signing up with his partner. Therefore, the non-disclosure clauses, the importance of showing in the contract what information is being shared. If necessary, copyright may be obtained. I would advise all of your clients who are going to share proprietary information to go and get a copyright registered, which is a simple process. Get a copyright on the material that is provided, so that if and when it is shared to a prospective business partner, it cannot be violated and you will have control over the proprietary information. Now, these are innovative methods and mechanisms that you use in protecting your client's proprietary information, his financial risks, his legal risks, and then you ensure that the brand does not suffer on account of a bad image, where you protect yourself in the clause in saying that should something untoward happen in a contractual arrangement, it is not the company that has not committed the wrong that will suffer. For instance, if you are the contracting party, you must protect the reputation of the company in the event of a misuse of any of your services, products, anything that is being done. Because ultimately, any untoward incident will result in you recently saw the Suez Canal blocked. Now, there was this company called Evergreen, which transports these containers, etc., and all of that. So you could very well visibly see that there's a shipping company which is carrying out the thing which really goofed up, and that could cause tremendous damage to the company's existence. And it may not be possible that the company, which is the shipping liner, is at fault, and maybe just the crew. Various in shipping areas, some of you know shipping areas, that the ships are registered in different countries, and the ship is leased out to another company which will manage it, and so on and so forth. So therefore, there are issues where you have to protect the corporate entity that you're representing. Now, so far as compliances is concerned, I think the time has come for standardization of compliances. In India, if you see, you have the central bank, where exchange rates, for instance, delays in fluctuation of exchange rates becomes an important issue in a transaction. Labor laws, laws relating to the corporate entities, registration of companies. I have this investor who's in London, who's invested in land where the money has passed, but the regulations have not been taken because he can't do more than 49%. He has gone and put in 65% or whatever. So therefore, they're going to be the exchange regulations in an international scenario are very important. And the time has come for using certain standard terminologies in terms of corporates right across the world, and governments also, for licensing, for all the controls. And we have got today technology which is to be utilized. I think all modern businesses must have a technological architecture which will give you a checklist of what all will be the compliances that are required in a foreign jurisdiction, and some of which are sophisticated and require little fine-tuning. There are requirements that you are dealing with a company which is already in business, but it requires fine-tuning. It's very important to read and understand and discuss various contractual agreements with the parties concerned, sometimes in detail. Labor laws, exchange regulations, corporate. In India, we have what is called as a company secretary. Beyond a particular size of the company, the company secretary is an official qualification recognized by those who deal with compliances for the company, regulatory mechanisms, with the Security Exchange and Board, which is called the SEBI. In the US, you call it the SEC, Securities Commission, which deals with your stocks and shares in the market. So these issues in India, we have got a very standardized plan of how these are to be dealt with, and similar such situations will have to be perceived, have to be. Now, the other aspect which I want to touch upon is dispute resolution. Now, the UNCITRAL, UN Commission on International Trade Law. I would advise you, if those who have not looked up this, the UNCITRAL model of arbitration and dispute resolution. It's a fantastic, fascinating document created by the International Law Commission in dealing with international trade law disputes. It's called the UNCITRAL, UN Commission for International Trade Law, UNCITRAL model of rules and regulations for arbitration, which are a standardized way of dealing with dispute resolution. So therefore, it's a uniqueness and imagination on the part of the lawyers who will make the risk, who will look at the compliances and assess the compliances required, and also take the legal steps towards keeping that under control. And it would be a problem that you can foresee, and a problem that you have attended to, which helps your client, protect your client from any trouble, is something that you will be credited for, not to deal with a problem after it has arisen. The greater part of all good legal advice, consultancy, and support is where you prevent disputes and legal problems from occurring on the basis of your experience, where you have seen some similar situations, and you can imagine the kind of scenarios that may emerge. Force majeure clause, everybody knows. But also it's very important to read up on dealing with this. I know transactional lawyers usually look at transactional stuff, but do look at the cases that have arisen in transactional scenarios. I would advise you to look at the disputes that have arisen in situations where when you're adhering or reviewing a contract that could have arisen. So it is very important for transactional lawyers to look at law that has arisen, because you can actually get to know what is a dispute that is likely to arise in such a situation. Because I'm a litigator, 60 to 80% of my my work is court-based litigation. I see disputes when they arise. So I can understand and help those better, I would say, in some fashion, because I see the other part in drafting that contract by envisaging what is a possibility, what could lead to a litigation. Because litigation is unproductive in any country. It consumes time. We'll discuss more of this. I will hand over to Hassan, and so that he can make some presentation. Thank you.
Thank you very much, Doctor. I have a presentation. Yes, here we go. And if you don't mind, I'm just going to stand, because if I sit, I'm going to speak forever. And being mindful of the time, I'm just going to get my stopwatch. I was told I have 7 minutes. I'll try to stick to 7 minutes. And here we go. So thank you, everyone. So I am Hassan, and I'm the Vice President and General Counsel of FedEx. I also look after government affairs and human resources. I'm based in Dubai, and I'm here today to talk about compliance during the pandemic, what has changed, and also how to make sure that we have an effective compliance program given this new environment and this new normal. Next. Do I have to? Is it working? Sorry about that. Okay. So, I know the slide. I can tell you what is in there. So, there is 3 things I wanted to touch on about where we stand today with regard to compliance. First of all, what has changed in the workplace? Then what has changed with your consumers and third parties? And last but not least, what about the money? Normally there is some animation and you will see things at some point. So the first item I wanted to say that, yes, with the pandemic, we had massive changes on the way we work. People working from home, everyone is online. This has changed. This has changed dramatically for everyone. And because of this big change, people felt, well, I'm working from home, so maybe this policy is not applicable. Or maybe now it's okay to do it that way. So what has become really important is really to remind everyone that those policies are still in place, and there is still zero tolerance for non-compliance. But it was very difficult to communicate that while everyone was working from home. So we had to find ways to make sure that people continue to do the right thing at all the time. And it was not an easy thing. It has also changed dramatically on the way we interacted with our third parties as well as with our customers. Let me give you an example with third parties. Well, we used to meet face-to-face, to negotiate face-to-face, and to sign with blue ink our contract. No. Now you send a WhatsApp, and guess what? It's our contract. Just because we work from home and there is a lockdown, and this is how we do it. So again, we had to change and to adapt the way we interact with our third parties, how we do our due diligence, and it has been a big shift on how corporations handle and manage things. 2 big risks on the way we interact with our customers as well as with our third parties. And one of them, since we are all online, has been the cybersecurity. Doctor touched on that, sharing password, having access to other Wi-Fi, and so on and so forth. This has increased the risk of cybersecurity and cyber attack. The other one has been data privacy. Since everything is online, we all jump on Zoom calls and Teams call at any time. We invite each other. What about the privacy in this? Is your GDPR policy taking into account this new way of working? And last but not least, economic climate. I mean, certain companies, including FedEx, have benefited from the pandemic, if I may say. Why? I mean, because you were all working from home and we had to deliver everything you needed, including masks and sanitizers and so on and so forth. Just to give you a number, FedEx delivered more than 2 billion of masks during the pandemic and 67,000 tons of PPEs. But yes, for a lot of other companies, they shut down. They reduce their customers, their turnovers. So they try to reduce cost. And guess what? When people try to reduce cost, they look at legal or at compliance as a cost center. And they try to, hey, since we all now work from home and there is not enough budget, I mean, you cannot do that program or we cannot use that software anymore just because we need to reduce cost. And this is where we, as legal professionals, we need to interfere and we need to basically remind them that compliance is important and compliance is not expensive. And on the previous slide, you had a say, but I'm going to tell you a say of the former U.S. Attorney General, which is, I really like it very much. If you believe compliance is expensive, try non-compliance. Because, I mean, doing the right thing is really very cheap and a competitive advantage in the long run. So if your CFO is telling you, hey, let's cut on cost, just tell him, hey, the penalties and the fines that will expose us is going to be much more expensive than adding 1 or 2 FTEs or employees into my team. So again, now, how do we do an effective compliance program in this environment? And in here, I just wanted to say one thing, is we had that dilemma at FedEx. How can we ensure that our compliance program is effective? Effective if you work from home, if you come to office, and is also up to date with the baby boomers as well as with the Generation Z. And we came up with this, it's all about culture. It's all about how you educate your people. And the most important thing for us has been to ensure that people are doing the right thing, even if no one is watching. Because in this environment, I mean, at some point, I mean, and you were saying that when you have not seen nobody for a year or so. So how do you ensure that he does the right thing, even if no one checks on him, no one sees him? And then we came up with all 3 things, which is communication, data-driven approach, and keep upgrading and evolving with your time and with the technology. So the first point about communication, and I am already 1 minute beyond my time. I'm going to wrap it up very quickly. So about communication, don't come from the top. So you need to make sure that you engage your senior executive and to make sure that they communicate the importance of compliance toward the organization. And how do they communicate? You need to use all the channels possible. So the face-to-face is no longer possible in a lot of settings. So you need to use your emails as well as your social medias. And I know that a lot of companies who are very old school, no, Instagram, Twitter, I mean, LinkedIn maybe. But I mean, now, I mean, you have to address the elephant in the room. I mean, you cannot avoid communicating on those platforms. Otherwise, you're going to miss a massive part of not only your employees, but your customers as well as your third parties and prospects. Now talking about data-driven and risk-based approach. Everyone is online. What does that mean? That means that you have more data. Raw data, but more data. You have access to a lot of more information than you used to have. You need to review them, analyze them. There is a big buzzword which is called artificial intelligence or data analytics. Actually, you need to use them. to build on your compliance program. Those data have a meaning if you have the right amount of people and if you know how to utilize them. Well, I was very reluctant because even if I don't have much gray hair, I'm very old school. And when they were talking to me about artificial intelligence and, well, we have this software that's going to change your life, and I was like, oh, no, thank you. Let me do a training face-to-face and have the people come, register, sign, and now you can't. And I've experienced a few artificial intelligence and software, and believe me, it changed my life in terms of contract compliance, in terms of effective trainings, in terms of due diligence. I mean, you need to be up to date with your IT department, which is new in the market when it comes to a data-driven and business analytics. Last but not least, it's to evolve and to continue to upgrade your programs. It's very easy for me because in addition to be the general counsel, I'm also the head of HR. So I'm keep understanding how your competition and the rest of the industry keep up with the pandemic, and how are they going to do after the pandemic, after we can all again shake hands and hug. I mean, are you going to change the way you work? Are you going to change the way you operate? And it's really important to keep your eyes open and ears open, and to also benchmark what others are doing. I mean, what you're doing might be great and good, but it's always important to benchmark and to keep sharing best practices. And that's one of the reasons I'm here today, because even though I strongly believe that our program is robust and sound, I mean, we keep changing it every other day, just because there are certain things that we may have missed, or there is this industry leader in that particular area that thought about something that actually might be implemented. So important to stay up to date and to continue to upgrade. Hey, that's all I have for you guys today. Thank you for having me. And if you have any question, I'm only taking easy question. Complicated question is for the PhD that we have here. And technical question is going to be for our SAP lawyer. Thank you. I mean, if they want to chat with us, otherwise I think the coffee. Yes, the coffee is there. Just if this is a question.
So yeah, that's fine. That's fine. So we'll quickly have a Q&A session and probably have some questions from you, and we can have a little debate. But before I start, something that just came to my mind, and all of you are lawyers here. I think it's very important to reduce agreements and contracts and simplify them. There's good old days, you would have pages and pages, and lawyers. I mean, I feel that lawyers can charge for whatever they want, even for one page, provided it has the right content. The right content is more important than having pages and pages of agreements, whether it's your bank or your insurance company, or is it, it's just go onto internet and when you're signing up for something and you say, I agree, and you've not read anything. But that doesn't, is not the culture that we should continue to have. I think we should have more, using fine print to dodge or protect your clients is not the way to do it. The way to do it is to make aware through the simplification of the contract or the agreement. And that's something that I would like you to have a takeaway, because I have seen numerous legal documents which run into pages and pages which mean nothing. The most important, crucial things, there's nothing in this world that you cannot include in one page. And that's the time, this is the WhatsApp age. So we must reduce the size of our, contracts and, disclaimers, etc. So with that note, I would urge you to, ask any questions, anything you want that comes to your mind or you would like to ask any one of the panelists.
And just so you guys know, we're going to have 3 questions maximum. And we need to wrap them up in less than 5 minutes.
Any comment, any question from anybody to any one of us or all of us? Yes, that young man there. Will somebody carry a mic to him? Yeah, we've got 3 mics here, so 1 mic can go with. Oh, you have already.
It's going to be the last question because I'm sure your question is great. Okay, I'm sure. I can tell.
Okay, yeah, thanks, Manna. So one issue that I think a lot of lawyers do face is we have clients who are a bit too enthusiastic. They very often want commercial arrangements to start before lawyers have actually had a chance to put into place the necessary paperwork or even any paperwork to help them hedge their risks, help them to protect them against their risks. Clients sometimes tend to feel that the commerce has to move faster. And so how would you best try and deal with such clients, deal with such situations where, especially in terms of startups or idea or opportunity-based commerce, where clients are like, look, I have to act on this now, otherwise I'm going to lose out on an opportunity. And on the flip side, you have lawyers saying, look, you have to put in certain protective, definitive documents. Otherwise, there might be great reward, but there's an even greater risk.
If I may share my thoughts on this. So I think modern day enterprises, particularly those who are providing standardized services for all their client base, this can be different forms, can be professional consulting services, can be multi-tenant cloud environments where you're providing the same cloud service to all of your customers the same way, or it might be delivering equipment or whatever. So I think we need to have some standardization around the contracts which reflect the products that we are providing to the customer and also the services and our capabilities that we deliver and our support and our warranty and everything which goes hand in hand with what we are providing. You know, many global companies provide global round-the-sun support, which means that someone in Argentina or China can resolve a support ticket if there's a support issue. And therefore, there is a need for standardization. So to come back to your question, moving quickly, yes, we can move quickly, but the starting point, I think, should be the service providers' operational documents should be the baseline. So these are normally via a web link because they can be updated regularly and then they will be revised in accordance with the support operational policies of that company or organization. Of course, there are room for maneuver on commercial, on fees, on payment structures and start dates. And these can be incorporated into an order form, which is the, if you like, the starting point for the discussion, which references all those underlying terms and conditions via web link. That's how I see it.
Let me give you a quick comment on that one. Don't be a pushover. Very simply, you have a client who's pushing you. You just tell him, if this goes wrong, you're responsible. I will do it if you want me to do it. You have to have a personality of inspiring confidence in your clients. The client must know that what you are talking is is the right thing, makes sense, it's logical. Please explain to clients who try to get pushy, because clients may be paying you your fees, but like at the end of the day, you represent them. You are delivering the end product to them. So therefore, it's very important to inspire that confidence. It's very important to logically explain to them, and don't be a pushover and tell them, if this goes wrong the way you are asking me to do it, you will be responsible. And let me tell you, I have the experience to do that, and you must have that experience to do that. Thank you.
Well, good question and perfect answers. So I guess we are ready for question number 2.
That was it. Did you raise your hand, madam, before? I didn't notice that. Yeah, after the lady. After the lady, please give her a mic. Please introduce yourself. We're happy to sort of know. Yeah, this lady here, right in the front. Yeah.
Hi, everybody. I am Vania. I live here, but I'm from Brazil, lawyer, of course. Well, it's about compliance. I'm compliance officer. I understand it's easy for the company now in this situation with the COVID problem, training the people how to be compliant at home. That I guess everybody's doing. But my question is how to control this risk at home. How, for example, data privacy. How the employee using their own computer, their own network or wherever, how the company are leader with the control about this data privacy, for example, but any other risk that may relate it to the company.
Well, I knew she had a tough question for me. So I'm going to try to address yours. Well, I'm very fortunate to sit here and to work for a Fortune 500 because we do have equipment, resources, and budget to ensure that all our employees who are working from home have the latest technology, compliant devices, and we do have also means to review and check their performance to know what they do and how they do it. So for me, I mean, to address your question, it's really about having the right equipment in place, having the right training in place, and making sure that you do checks with your employees from time to time on whether they're doing what they're supposed to do. Now, if I were to give you an advice or to let you start thinking about ways and means to control compliance, if you were to work in an environment and in a company where employees won't have the chance to have the latest equipment and to work for a big company which is very sophisticated, I think that's what I was trying to touch on. It's all about culture. And it's all about doing the right thing, even if no one is watching, which is the most difficult thing. And I know it might appear a bit theoretical, but if you bear with me for a second, I'm just going to tell you that, well, no matter what control you put in place, no matter if you have a CCTV above the head of each and everybody, if someone wants to do something wrong, they'll do it. They'll do it. You can have 5 law enforcement around them. They'll find ways to breach those policies and those laws. The only way you can resolve that equation is to incentivize them. Then if you do it right, it's good for you, it's good for us. It's to educate them that if you do it right, it's going to be quicker, faster, and better. And if you do it right, you're going to grow and be promoted and make more money and etc. And this is where the culture of compliance kick in. And this is where you have a lesser oversight and have a more trust on your employees. Again, I do have a lot of materials on how to overcome the IT side of the compliance spectrum with the people side of it and the educational. I'll be more than happy to share that offline with you, because that's a debate that we can have for the next 3 years. But in the interest of time, I'm just going to thank you for your question. I hope I gave you some food for thought.
We'll answer hers and then we'll just finish it, right? I'm tempted to answer, but just 10 seconds I would say. It's very important to train people. You must understand that during your initial training, if the person is fit for the job, he's an HR man, he'll tell you. If he's not fit for the job, assign him something else. Training is key to everything. All of us work for somebody, and all of us have somebody to work for us. And you have to ensure compliance is about obsession. There people say OCD, I say obsessive compulsive syndrome. They have to be obsessed by doing. I have an employee, you tell him one thing, he keeps on doing the same thing every single day, which is told. So you have to train your employees to do that, the checklist, and therefore that's the important part of it, where you must know, otherwise you don't have them. You need not be impolite to them, you may assign them other works.
Yeah, I totally agree. We're just finishing up now for questions later. But just to add my 2 cents, yeah, I think compliance starts with each and every one of us, including our salespeople. They have to understand that, they are on the front line, and compliance is number one with them to adhere to.
So that's it, I think.
Thank you
very much, all of you. We can talk over lunch, etc. Lovely being here.